If your firm handles customer data, and let's be honest, every firm does, then you need to know exactly what the SEC now expects you to do when something goes wrong. Not in theory, in practice, with a clock ticking. And that's what we're going to be talking today on the Endcast. My name is Rafael De Leon. I'm the Senior Vice President of Industry Engagement here at Ncontracts. And before joining Ncontracts, I spent 32 years with the Office of the Comptroller of Currency, and most of that time as a credentialed national bank examiner. So I've seen firsthand from both sides of the examination table how regulatory expectations and customer data protection have evolved. Today, we're doing a deep dive into the SEC's amended Regulation SP, the most significant update to customer data and privacy rules for investment advisors in a generation. And I want to ground this conversation in data. Ncontracts just released our 2026 State of Third Party Risk Management Survey, and we received responses from 173 financial service professionals telling us what really is happening on the ground with vendor oversight, cybersecurity incidents, staffing, and AI risk. We'll weave those through our findings throughout this episode because they paint a picture of an industry that knows that the risks are going on, but is really struggling to keep pace. And I couldn't ask for a better guide through the regulatory landscape than my guest. Tracy Zurley is my guest. And Tracy, I'll turn it over to you. And why don't you share with us a little bit of your background?
Sure, thank you. My name is Tracy Zurley. I'm Associate General Counsel with the Investment Advisor Association, which is a trade organization that represents registered investment advisors in Washington, both on Capitol Hill and with the various regulators, including the SEC, the Department of Labor, and the CFTC, among others. I've been with the Investment Advisor Association for about a year and a half. And prior to that, I was a managing director at Affiliated Managers Group in Boston, Massachusetts, where I worked with AMG and its various affiliated registered investment advisors on legal and regulatory compliance matters. Prior to that, I was also held compliance roles at State Street Global Advisors and Wellington Management Company, and I started my practice at the law firm Deckert in Boston, which in the financial services practice.
Well, again, that's one of the reasons I was glad to have you here on the show with us today because the wealth of background that you bring, especially to the space, that we're talking about today. So let's start at the top. Regulation SP has been around since 2000, but the SEC adopted significant amendments in May of 2024. And for our listeners who may not have been tracking every detail of this rulemaking, what are one or two changes in the amended rule that represent, in your mind, the most significant shift in expectation for investment advisors? And what was the SEC really trying to accomplish?
Yeah, so I think two of the major changes that the amendments to the rule were first, the requirement to have a mandatory incident response program, and as well a mandatory customer notification requirement. So prior to these amendments, Regulation SP really prescribed opt-out notices. You had to give copies of your privacy notice to your clients, but there was never an obligation that you had to notify your clients in the event of a breach. And so that those two things are quite new. There's also a requirement for service provider oversight that's quite new and quite onerous to comply with. So as you said, the rule was adopted in 2000, and the substance hadn't really changed much since then. But the nature and scale and impact of data breaches has increased substantially. So the SEC wanted to modernize the rule to help protect the privacy of customer data and require firms to notify their clients in the event of a breach. Basically, sort of right in line with basic investment protection principles.
And so we're really seeing more of an alignment with, with financial providers, anyone that is dealing with this type of data in terms of what the regulators are looking for, from the federal banking regulators to now the SEC. and other agencies because of a lot of these challenges that you just talked about, especially with data breaches and what is happening and how are vendors using their data as with more plug and play that is going in. So I think again, one of the most significant pieces of this is this kind of 30-day notification clock. So under the amended rule, when a firm becomes aware of an incident involving unauthorized access to sensitive customer information, the clock starts. 30 days to notify affected individuals. That's not a lot of time when you factor in the investigation, the scope, the assessment, the drafting of notification. So, Tracy, what are the biggest operational challenges firms face in meeting that timeline? And what should they be doing right now so they're not scrambling when an incident occurs?
Yeah, the biggest operational challenge with meeting that 30-day timeline is that breaches often take a lot longer than that to investigate and make a reasonable determination about whether breach has actually occurred and then which of your clients may have been impacted. I think having a detailed incident response plan and certainly a cross-functional team of people ready to respond to a breach is imperative to meet that deadline. This can be challenging, particularly for small firms and for firms that outsource IT or use managed service providers. Those vendors need to be able to respond quickly if the firm has a breach. So, in terms of preparation, you really need to be in touch with any service providers and your cross functional team, and you need to know exactly what you would do in the event of an incident. You mentioned some of the things that take a long time, including drafting a response. Those are the kinds of things that you could have prepared, at least an outline prepared in advance, so that when you're in a situation, you have materials at your disposal that'll help you figure out what to do and when you have to notify.
I think, and what you're really talking about here is tabletop exercises that they could be performing so that they are ready. And I know that, again, I'm going to go back to my knowledge on the banking side. This has really been helpful for those that have done that, and especially who is going to say what for the firm to making sure that there is a consistent message and how they're addressing it so people are not stepping over each other. It helps to define the lines of control and who's responsible for what and when, and how this data is going to be collected. So I think that there are those operational challenges, but that can be soothed, like a preparation and training that we see in this. But those communication and who's going to handle that are really pretty significant. When you're looking at these things. I know that I've had friends that have talked to me after a data breach and said, I got a notification from my institution that there was a breach, but this all started a year ago and I'm just getting the notification. And I think those are challenges too, when you know in this day and age, like, well, this happened a year ago and I'm just getting a notification. It doesn't do a lot to engender trust. So, do you have any thoughts or suggestion when institutions say, how do we handle that when we're in the midst of an investigation?
It's an interesting question. Obviously, the rule imposes the 30-day deadline, and it's very specific, I will say, in terms of if you follow a reasonable investigative process, but that process is inconclusive, the rule requires you to notify every client whose data may have been in whatever system was breached. Um, so it's important to have a cross-functional team that's at the ready and available to you to get that investigation started and to move as quickly through it as you possibly can. Because at the end of the day, you will have that 30-day obligation. And although the standard is, when you become aware, I think that once you are aware that there's been some access to your system, even if within that 30-day period you can't finish the investigation and conclude for certain that someone's data was compromised, the SEC expectation is that by the end of that 30 days, you will file that notification.
Yeah. So if I have this correct, the rule includes an exception if you can reasonably determine that the data is unlikely to be misused, the notification isn't required. So how should firms think about that reasonable basis? And I'm also going to talk about reasonable assurances, and if you can discuss those differences to the best of your ability.
Yeah, so a reasonable basis to believe, um, it's a tough it's an intentionally vague standard, I would say, and it is tough for a lot of firms struggle with what is a reasonable basis. And as you noted, the rule starts with the premise that you must notify unless after a reasonable investigation you determine that sensitive customer information has not or is not reasonably likely to have been used in a way that would result in substantial harm or inconvenience, which is also an undefined term. So uh,
And then,
it's
well, let me interrupt you there because I'll go into the next question, which kind of leads into those reasonable assurances because I think they tie in, and we can. I think I got the basis that we were talking about there. But the amended rule requires firms to have written policies and procedures that are reasonably designed to require oversight of the service provider, including thorough due diligence and monitoring. And service providers are now required to notify the covered institution within 72 hours of discovering a breach. So they're third party discovering a breach. So my question is, what does reasonable assurance actually mean in contractual terms? And so that's why I just wanted to break it out to make sure. So again, what does reasonable assurance actually mean in terms of contractual terms? And are standard vendor questionnaires still sufficient, or does the rule push firms towards something more rigorous?
Yeah, so nobody knows exactly what reasonable assurances are, and we haven't gotten any guidance from the SEC. We do know that there is no requirement that this be in the contract. And that is, frankly, one of the most challenging aspects of the rule. When it was originally proposed, the requirement was going to be that advisors had to go back and renegotiate all their contracts. And as I'm sure you're aware, a lot of firms just don't have the leverage to do that. And so, in the final rule, they did take out the requirement that this be contractual. So you're sort of left with, as most things are in the compliance world, of facts and circumstances determination.
Mhm.
And so the challenge is that many firms don't have the leverage to get assurances either. So the best they can do is their own diligence, look at what's publicly available, try to have conversations with the vendors to the extent that you can, and then document everything you did to get comfortable that you can reasonably assume that you will be notified within the 72-hour period. I will say that some of our members have taken the approach of notifying the service provider of their SP obligations and their expectation that the service provider will notify them within the 72-hour period, sort of a negative consent type of process. And some vendors just don't respond, but others have responded that they will not commit to that obligation. The first thing you usually hear is, well, that rule applies to you, but it doesn't apply to me. And so we're not going to give you, we're not going to confirm for you that within 72 hours we'll be able to provide you with that notice.
Yeah.
And so it's unclear whether the negative consent process is an acceptable approach, but it's kind of a mosaic. And what you want is a process that you can document that shows that you did all of your investigation, even if the vendor wouldn't commit to the 72-hour period, that it was reasonable that the vendor will likely notify you. And some of them will say, we'll work with you, but we just can't commit either in writing or verbally that, we'll provide you with this notice within 72 hours.
Um, there's just kind of a fine line there. Are you starting to see or hear from any firms renegotiate their contract with their service providers to address that notification requirement? I realize some may not want to engage, but The same parallel I use with financial institutions, with banks and credit unions, is that you're in the driver's seat. They are a customer of yours. You have the ability to ask for, this is what we're expecting and this is what we're requiring. And if they can't provide it, maybe it's time you look at another provider. So let's go back to my first part. Are you seeing that people are making updates in terms of their contracts?
Where they can, absolutely. With vendors that are willing to renegotiate, people have gone down that path. There is a very large bucket, though, of service providers that will not engage. Their contract is their contract. So if you're using, a cloud service provider, or you're using a popular client relationship management software company, or you're using 365, you're not going to be able to make any progress with those
Right,
vendors. And
right,
so the best you can do is diligence. And a lot of those vendors have great disclosure on their website that allows you to get comfortable that they're subject to privacy rules and regulations, that they may even have certifications on their website. So it's, like I said, it's facts and circumstances and kind of the totality of the diligence that you're able to do. Because at the end of the day, if you have a major service provider, for example, Office 365, it's hard to change. It's
right.
hard to change vendors from an industry
Yeah.
standard vendor.
On some of those, yeah, larger vendors as well. But again, to begin thinking about that process and what can we ask for and what should we be asking for, and more so importantly, what did we ask for that we didn't get a response to? Because
Yes.
after every one of these data breaches, we're seeing class action lawsuits. So I'll share something from my kind of days, as an examiner in the banking world. We would often tell financial institutions that uh, you can outsource the function, but you can't outsource the risk. And the SEC really made the same point here, that firms can delegate notification to a vendor, but the ultimate responsibility stays with the institution. And that's a powerful statement. And advisory firms, are they internalizing that? Do you see them building that in?
Oh, absolutely. I
Yep.
mean, you can't outsource fiduciary duty. And so even even in other circumstances outside of SP, when an advisor uses a proxy voting vendor or any other sort of platform to exercise their obligations as a portfolio manager to a client, then they still retain responsibility for oversight and for compliance. And so I think that people are definitely internalizing that obligation. And that's why, as they're looking at their risks in terms of privacy rules and breaches, they're not just looking at their own systems and their own practices, but they're looking at the practices of the service providers as well.
Right. And, beyond the initial due diligence, there's, requirements too around ongoing vendor oversight. It's part of the kind of entire life cycle that they're looking at. Um, and what is, under the amended rule, is an annual questionnaire enough, or should firms be thinking about more continuous monitoring, maybe quarterly, yeah.
Yeah, so the rule does specifically say that certifications are insufficient. So in the adopting release to the rule, the SEC did give some guidance there. So you do need to do something more frequently than annually, I would think. It also depends on the type of service level agreement that you have already with your service provider. So if you're using a custodian, for example, they probably already have a quarterly process. You probably already get a copy of their audit, their SOC 1. Those are operational items that you can get that, again, give you comfort. You can still get certifications that we haven't had a breach, or with some cadence that works for you. But just a simple certification is not going to be enough. And so there is a level of ongoing due diligence that you'll need to do to remain comfortable.
Yeah, and I think some of those things are dependent upon what we're going to talk about because when we talk about all of this vendor oversight, all of this incident response, it depends on knowing what data you have and where it lives. So let's talk about data mapping. I want you to spend a few minutes on this because I think this is one of those areas where the rules requirements can feel straightforward on paper, but get complicated very quickly in practice. You can protect what you don't know you can't protect what you don't know you have. You can't notify affected individuals if you can't identify them. So data mapping is foundational to everything. How should firms approach that exercise? And what do you tell firms? When the honest answer is we're not entirely sure where all our customer data lives.
Yeah, I mean, look, it's not required under the rule as you noted, but a data mapping exercise to identify customer information, where it resides, who has access to it, and how is it protected is really the best approach to compliance. And the SEC has given 3 outreach seminars on the topic of SP compliance, and in each and every one of those seminars, they talked about the types of information they would be requesting during exams, and a data map was one of the first things that they mentioned. So the goal of that exercise is to document company data inventories and data flows, basically, including information received from other financial institutions, information received from customers, information provided to your service providers, and that's
Mhm.
applicable to both paper and electronic records. Um, so I think data mapping can really facilitate compliance with the requirements because it's hard to imagine having a program that's reasonably designed to prevent, detect, correct these types of breaches and then to mitigate and notify when required if you haven't done the exercise of data mapping so that you know where the data is and who has access to it.
Yeah, I think that is one of these key fundamental areas is knowing who has access to what, and not everybody needs to or should have access to everything. So you really understanding where your data resides, and I like to talk to firms that say, your data are the crown jewels of your organization. If that data is exposed or compromised in a data breach, you're all of your customers are going to be wondering, can I continue trusting this company to protect my data and who I'm dealing with there? So, I think again, you touched on this, but I wanted to reinforce it. The amended rule broadened the definition of customer information to include data that is held by service providers on the firm's behalf, even if it originated with another financial institutions. So, how are firms handling this expanded perimeter? Do you think they're aware of that from what you hear, or do you think they're still learning as we're approaching the dates?
No, I think in my experience, people are definitely aware of the requirement. Um, I think the trickier one is when you are hearing or receiving information from another financial institution. An example of that is in the private fund context. So private funds aren't subject to the rule. But advisors to private funds are subject to the rule. And so, as an advisor to a private fund, um, if you have access from that private fund, which is a financial institution, to the limited partner list and information about those individuals, then you're actually in scope for the rule. So you were in scope as a registered advisor to begin with, but your risk goes beyond just the fund as your client. If you have information that you've been given from the fund, um, and it is information about individuals, then you actually do need to apply Reg SP protections to that data.
Yeah. And I think this is the other area, when we go beyond data, it's on their policies because firms may have individual policies on privacy and other, policies on cybersecurity, and then still others on vendor management, and usually living in separate silos. Do you have any thoughts how firms could make sure that the amended rule is reflected holistically across all of these programs?
I think it starts with a cross-functional approach
Yeah,
to compliance, frankly. Everything we've heard from the SEC, the group within exams, the technology team within exams that's examining for Reg SP compliance, they are looking at all of that holistically. They want to see your cybersecurity policies. They want to make sure that what you're saying in your cyber policy is reflected in your privacy policy, and that it's all interconnected and that they don't conflict with each other. So it really does start with a cross-functional team of all the stakeholders to help pull together where all that information is, and where it resides, and then amend the policies accordingly, but do it across.
yeah.
I think that's extremely important because that's one of the first things that we're going to see the SEC looking for in exams.
So let's bring this full circle where it really matters, the examination. When an examiner walks in the door, what does regulation SP compliance look like in practice? And the SEC's Division of Examination highlighted Reg SP compliance in its 2026 priorities. So what does a strong answer look like when an examiner walks to the firm to look at their incident response program?
So, during the SEC's outreach program for smaller advisors, they actually talked about the types of things that they'd be looking for in exams. They were careful to say, and we've heard from senior SEC officials, we've heard them repeat this publicly, that this is not expected to be a gotcha type of exercise. But in terms of SP compliance specifically, we know that they want firms to provide copies of their policies and procedures, copies of that incident response plan. If you have an IT arrangement or a managed service provider arrangement, they actually want to see the contract. Um, they want you to provide information about the IT governance model, including your committee structures, reporting lines, reporting mechanisms and frequency. They expect to see documentation of any internal investigation regarding privacy, specifically, or information security issues. They want you to be able to demonstrate that you followed your incident response program, and that you documented it appropriately. They also want to see your risk assessment, which is going to be related to technology, cyber risk, controls, threats, vulnerabilities. That includes that data mapping exercise that we talked about. They've consistently said, their common observations that they've cited, including policies and procedures that did not appear to be reasonably designed. So again, you talked about, does the cybersecurity conflict with the privacy policy? They want to make sure that it's tailored to the institution, that it makes sense, and that you're following it internally. They've also said that they've had issues cited in exams for policies and procedures that weren't enforced. So if you have a written policy, and it actually doesn't work for your business because you can't actually follow it, that's going to be a problem in exams as well. And of course, if your policies and things that they're asking for simply do not exist, then they're going to have more significant concerns about
Yeah.
about your process.
Yeah, very true on that in terms of, again, my experience on the banking side and the challenges they're facing there. Um, so, what I looked for when I was examining banks, I didn't want to just see the policy binder. I wanted to see evidence that the program has been tested, that they've had the tabletop exercises, and especially that the policies are updated. When I would find policies that didn't match what practice was, it didn't give me a lot of faith and confidence in the program that they were doing it. It's just like, or we're trying to keep up. So I'd expect the SEC examiners to really take the same approach. And you shared some of that from what you were hearing from a lot of these last three surveys. Anything to add on that topic?
You know, when they did the marketing rule, they went through a process where they, in the exam setting, they interviewed folks and talked to them about what changes they had made to their programs, how had they approached um, the compliance program as it related to the new rules, and show them how they had reflected the changes in the policies and procedures and the timing with which they did that. And to your point, was there training on that, on the new policies and procedures? Had they tested all of those policies and procedures? So it will be an exercise where they conduct a series of interviews, and they are specifically looking to understand how you approached it, the timing of which you approached it. Obviously, it would be a concern if someone had done nothing, the day before the deadline, and so they want to understand what kind of a reasonable process you put in place to make sure that you were addressing all of the requirements.
And the amended rule did expand on those record keeping requirements as well, that firms need to document compliance with the safeguards and disposal rules, and retain those records for specified periods. What are some of the practical challenges there are for smaller firms?
Well, those smaller firms, when you say disposal, that's the hardest part for smaller firms, because they don't throw anything away.
Right. Yeah.
Um, and see, look, some of the larger firms are the same. Um, so I think having to put in place proper disposal requirements can be a challenge, particularly when you, as most smaller firms do, have a lot of outsourced service providers. So that's a big part of the compliance process to operationalizing these amendments. Is you're going to make sure that your service providers not only are retaining the records that you're relying on them to retain for you from a regulatory perspective, but also when you terminate that arrangement with that service provider, or when the client terminates, that there is a reasonable process in place to dispose of the information when it's no longer required to be kept from a regulatory perspective.
I think that termination is just also a great point to bring up, because most financial institutions are thinking about it from the beginning. What do we have to do? Due diligence and gather, and what do we need to do ongoing? But they're not thinking of it in terms of cradle to grave, and what do we do at the end of life there, and who has the data? How are they going to be keeping it? So I think that's a great point. Tracy, before I let you go, I want to give you the last word. If you could give one piece of practical advice to a chief compliance officer at a mid-sized advisory firm, still has work to do before the June deadline, what would that be?
Oh, I would say, I think muscle memory is the most important element of a timely and thorough response to any compliance breach, privacy breach or otherwise. Um, Running tabletop exercises, training, creating an incident response playbook. What steps would we follow if we had a vendor breach? What if it was a denial of service attack
Right.
and customer information was involved, or a phishing attack that led to the breach, or ransomware? Just having run those exercises to know what steps you would follow make it so much easier for you to respond timely and efficiency to certainly a privacy breach, because you've got that 30-day deadline, but any other compliance breach for that matter.
Well, Tracy, I appreciate your time and energy on providing us and sharing with our listeners this very important aspect of Regulation SP, and as it's hitting these areas. I know it's newer for advisory firms, but again, if you talk to any of your counterparts on the banking side, we've been dealing with it. And my sense is we're going to see this throughout all of financial services that is happening because of the data that's out there and what needs to be protected. And Tracy, I'll give you just one more shot. Any other last closing thoughts about your organization and what y'all provide?
No, the Investment Advisor Association is, as I said, a trade organization that serves registered investment advisors. We have lawyers on staff that work on all kinds of legal and regulatory compliance issues. We have a database of information that's available. We have a privacy hub, which is a resource for members that have copies of sample policies and procedures and checklists, um, articles that are written by some of our associate members, which are, consulting firms and law firms, and other service providers. So we have a lot of resources available as you're approaching your compliance program. And so we just encourage you to check us out.
Great. Well, as we close, I'd like to leave you with, the fact that, keep in mind that you've got to do those, begin with those risk assessments. You've got to look at the data mapping. You've got to run tabletop exercises you should to really ensure strong preparation and ensure that your policies are consistent with your actual practice. So that's it for today. Stay compliant and stay focused. Thank you.